Mr. Commissioner.
Can you stand up, please, sir? Is your name Kevin Penward?
It is indeed, Mr. Commissioner.
No middle name?
I do have a middle name. It's Llewellyn. Llewellyn.
Llewellyn.
Nice Welsh name.
Indeed.
Good. Do you have any objection to taking the prescribed oath?
I do not.
Do you then swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Raise your right hand and say, "So help me God."
I do, so help me God.
Thank you very much. You may be seated.
Thank you.
Thank you, Commissioner. Good morning, Commissioner, members, and everybody. Commissioner, Mr. Penwarden is going to be testifying on the SA home loans transaction. Now, up to this far, we've had 2 PIC employees coming to testify on the matter, and the whole issue revolves around a 45 million rand arranging or origination fee requested by Mr. Mponya's MMI. Now, apart from Mr. Raja and Mr. Mangalo testifying, we also had Mr. Ian Simpson from Standard Bank, who also came to testify and give the version of events, including the session and everything that was involved in the origination fee. What Mr. Ian as well testified on was how the deal actually originated. He didn't have documentation at that particular point in time, but Mr. Penwarden has the documentation, and the Commission will realize that there's 2 bundles that have been prepared. In as much as the statement doesn't specifically refer to each and every annexure, Mr. Penwarden will refer the Commission to the relevant portion or annexure as he goes along. The other issue that was raised was the 2 individuals who have been reported to the Hawks. There was a letter that was attached to Mr. Raja's statement in that regard, and it was Mr. Penwarden was the author of that document, and he is here, and he will also clarify that. And in Mr. Ian's testimony as well, when the issue of the origination of the deal was dealt with, I referred him to the PIC internal document named the appraisal report, which in the document, which was signed by Dr. Den and a few other individuals, outlined how Mr. Mponya's BHC was actually the one which approached the PIC for the particular transaction. Mr. Penwarden will also deal with that in his statement. Thank you. Mr. Penwarden, am I correct that you are the CEO of SA Home Loans?
Yes, I am. I'm the CEO of SA Home Loans. There's also a holding company called SAHL Investment Holdings, and I'm the CEO of that company as well.
How long have you been the CEO?
15 years.
Okay. Am I correct that you prepared a statement for the Commission?
I have indeed.
And the statement in front of you, signed and initialed on each and every page, do you confirm that is your statement?
I confirm that it's my statement. Indeed, I have initialed and signed.
Do you confirm that you were not coerced to make that statement, and each and every fact in that statement is yours and yours only?
Mine and mine only, to the best of my knowledge and belief.
Thank you. You can start at paragraph 2 of your statement.
Ms. Go, can I just ask something here? Normally, the witnesses tell us who they are and their career and all that. Like I'm not seeing it here.
Mr. Commissioner, if the Commission requests Mr. Penwarden's CV or anything relating to his employment, he can provide the Commission with that. And if the Commission insists that he tells that at the beginning, it is also fine. I'm in your hands.
But that's fine. He has testified that he's CEO of the company for so long. I don't know if we need to know what type of work he does as CEO. You're in charge of virtually the business, as it were.
That's right, Mr. Commissioner.
Yes.
So I have ordinary operational responsibilities from end to end.
Yes.
I'm happy to give a brief CV if the Commission wants to hear anything.
And when did you start working after qualifying at university?
Yes, so I didn't go to university. I actually studied part-time through UNISA. I did an honours degree. I then qualified as a chartered accountant. And then I was working in the insurance industry first, the life assurance industry at Old Mutual, then as an executive general manager at Mutual and Federal Insurance, now called Old Mutual Insure. From there, I was the CEO of the South African operations of a British bank, the Robert Fleming Group. And from the Robert Fleming Group, I moved to SA Home Loans.
Thank you. You may proceed then with...
Thank you, Mr. Commissioner. So this is in paragraph 2, just summarizes what SA Home Loans does. Primarily, we access funding in the debt capital markets through issuances of commercial paper by special purpose vehicles, and we manage those special purpose vehicles. And we also get direct funding lines from large institutional investors, and that's obviously to enable us to provide home loans to our clients. The next section of my statement deals with some issues relating to the disposal of JP Morgan's shareholding in SA Home Loans. So in 2014, it was in fact June 2014, the Government Employees Pension Fund, represented by the PIC, and the Balacha Shlocha Consortium, we call that the BHC, they each acquired a 25% share in SA Home Loans from JP Morgan. The remaining 50% of the shares were held at the time of the acquisition by Standard Bank, and they continue to hold those shares. The process, however, to replace JP Morgan as a shareholder was initiated by SA Home Loans late in the year 2011, and that was a direct consequence of the liquidity shortage resulting from the financial crisis years of 2008 to 2010. And JP Morgan's, at that stage, inability to stand shoulder to shoulder with Standard Bank to assist SA Home Loans with our funding. It was apparent to us that we needed to have a second funding shareholder who would be able to fund SA Home Loans if there was such a need again in the future, in other words, another crisis, and that would enable us to continue to conduct our business. I understand that Standard Bank had similar discussions with JP Morgan, but I am going back to 2011. Following those initial discussions with JP Morgan to dispose of their shareholding, JP Morgan mandated us, SA Home Loans, to identify and approach potential and suitable acquirers of their shareholding. To this end, we decided we needed some assistance, and so we approached the Standard Bank M&A division to search for what we called a strategic equity partner to replace JP Morgan. The first workshop we had with the Standard Bank M&A team was on the 14th of March 2012, so it does go back a few years, and they presented to us a strategic document to take the search forward. And what they did at the time was they tabled a universe of potential investors. And amongst all of that universe, of course, the PIC was identified as a potential investor. I've made the comment that I'm able to provide a bundle of all of the documents, all of the presentations, minutes, etc., as needed. I did supply some last night, and there may very well be others which the Commission wishes to have. All the Commission needs to do is ask, and I will supply. Everything in my statement can be backed up by documents and presentations.
At this point in time, I just need to bring it to the Commission's attention that the bundles have been prepared, and the documents that he's referring to are already before the Commission if they have been provided. Because the statement doesn't specifically point to a particular annexure, I'll ask Mr. Pedwarden to just look through his file and just point out which paragraph, which document relates to which paragraph, sorry.
Thank you. Yes, so there were actually two bundles, and I hope I've got both of them here. So my point 8, where I talk about the 14th of March meeting with the Standard Bank M&A team, that is in the bundle. It is a clear document headed SA Home Loans Strategic Equity Partner Discussion Materials on the 14th of March 2012. And I've written on it, a first workshop with Standard Bank M&A team, paragraph 8. So that document I did provide last night. As I say, it's not specifically correlated in order to my statement, because I brought that along hastily with me when I flew out of Durban last night.
Ms. Kuwe, I don't know if you have a similar file as the ones that we have, because I'd like to ask you, is the document that is being referred to in this file? And if so, what exhibit number or annex number?
It's the blue tab.
The 14th, yeah, we do have the 14th of March. It's a Standard Bank document. Yes, that's the one. The 14th of March, I think.
Yes, that's correct, Mr.
That's the one,
Commissioner.
yeah.
Yes, that's the one I'm referring to in paragraph.
Yeah, we do have
8.
that. It's a Standard Bank. How do we mark it?
Please mark it as Annexure 1.
Annexure 1.
Yes, please.
All right.
And then I could point out, although it's quite a formidable document, many slides, but somewhere in the middle of the document is a slide, it's page 8 actually, that is headed Universe of Potential Investors. And one can see in the middle block, the PIC is identified as a party that we would have wanted to talk to.
Page 8 of the Standard Bank document.
Page 8 of the Standard Bank
All
document.
right. Okay, that's fine.
So following this workshop, various potential investors were then introduced to SA Home Loans by both Standard Bank on the one side and JP Morgan. And although several prospective investors conducted their due diligences, none eventually made a final offer for the JP Morgan shares. It was a long and protracted process, of course. During the process that I'm talking about, JP Morgan initiated and facilitated a meeting between SA Home Loans and the PIC to present a business case to the PIC covering two matters. Firstly, the rationale for the GPF to provide home loan funding for their members and the broader affordable housing market, and B, to acquire the JP Morgan shareholding in SA Home Loans. The meeting took place on the 21st of June 2012, which meeting was held at the PIC's offices in Sandton. SA Home Loan was represented by a colleague of mine, Rob Kelso, and myself, obviously, and the PIC was represented by Dr. Dan, the then Chief Executive Officer of the PIC. JP Morgan was represented by Mr. John Coulter, who was the CEO of JP Morgan Southern Africa, and I think he also had additional international responsibilities, because he was certainly the CEO locally here, and two of his colleagues. Now, I do have again, as part of my submission, I do have a copy of that document. It's headed SA Home Loans Overview with the date June 2012 under it, and it's got both a JP Morgan and an SA Home Loans branding on it. And that, I guess, would be Annexure B.
Which document is this? Oh, okay. The first one. Yeah. It's June 2012, no?
June 2012, that's right, Mr.
That's
Commissioner.
Annexure 2. Annexure 2?
B, I thought I heard.
Annexure 2. Okay. All right.
So this Annexure 2 was the presentation that we delivered to Dr. Dan. And Mr. Kelso and I dealt with the home loan funding aspects extensively. And in fact, from this document, one can see that we presented draft term sheets already at that stage in June 2012. At the conclusion of the presentation, we broke up into a smaller group comprising Dr. Dan, John Coulter, Rob Kelso, and myself. It was Mr. Coulter who pitched the added benefits of and the yield pickup for the PIC if, in addition to home loan funding, the PIC also acquired the JP Morgan shareholding in SA Home Loans. He did that pitch. There were several questions asked by Dr. Dan, but he certainly appeared interested.
In that, just for emphasis perhaps, what becomes clear through your statement is that the key player in the initiation here was JP Morgan.
Correct, Madam Commissioner. They worked in concert with us, but they led the way.
Just to add also, so the first meeting, was it about the PIC investing in SA Home Loan, or it was for the yield pickup, you know, for the PIC to invest in the funds themselves?
It was for both, Mr. Commissioner. Our intention before we went to the PIC was to deal with both, and the way in which we structured the presentation was that Rob Kelso and myself would talk about the funding aspects, the strategic fit for the GPF to provide home loan funding for their members, as well as for the shortage which we had in the South African market of funding for affordable housing, and then also to deal with the critical aspect of the yield pickup should the PIC also acquire JP Morgan shares. So it was a twofold objective.
Thanks. Thank you.
So following the 2012 meeting and presentation with Dr. Dan, in response to a request for Dr. Dan for a concept document setting out the funding and equity proposals we had presented, we compiled a document titled PIC Funding / Equity Concept Document, which we sent to JP Morgan, which we were informed was used for their ongoing conversations with the PIC. This document set out the strategic benefits for the PIC of a funding line for and an equity stake in SA Home Loans, in particular with respect to the provision of home finance to the GEPF members and in the affordable housing sector. This document effectively distilled from the big presentation that we'd given to Dr. Dan, it distilled it into a concept document and took all the principles into that document. Now, I have provided that as well. I would think that would be annexure, and that might be in my second bundle here.
The document's heading?
Is it the
Which
one,
it's
the
called-
SA Home Loans PIC Funding Equity Concept Document?
Yes, it is indeed.
That's this one?
That's Annexure 3 there.
Annexure 3, yes.
So it's called PIC Investment Opportunity in SA Home Loans, yeah? Is that the one?
And it's called, yes, PIC Funding / Equity Concept Document.
Okay. When is
So that we know was onward sent to Dr. Dan by JP Morgan, demonstrating Dr. Dan's interest in the proposals which we had presented to him at the 21st of June 2012 meeting. There were further requests from Dr. Dan, so in September 2012, we put together another presentation, and that one was the one called PIC Investment Opportunity in SA Home Loans. So that would be Annexure 4. So that was a fourth document which we prepared, and we also sent that to JP Morgan, and again we were informed they used that for further ongoing conversations with the PIC. And I point out that the opening slide states the purpose of the presentation as being threefold, but two of those certainly was the funding from the GEPF and the equity acquisition of JP Morgan's shareholding in SA Home Loans. So from our perspective, it was clear to us at least that the combination of JP Morgan and SA Home Loans were the first parties to present a clear business case to the PIC for both funding opportunities to provide home finance to GPF members and their SAHL equity acquisition. So I need to point out that there was then a hiatus, certainly not from a SA Home Loans hiatus perspective. We had several people coming through to do due diligences. We spoke to several other parties. Similar presentations to the ones that I've submitted today were made to other potential investors. JP Morgan remained obviously as a shareholder of SA Home Loans. We had board meetings. They kept us appraised of what was happening, and we were told that the PIC retained an interest in both sides of the presentations and documents that we'd put forward. In other words, they certainly retained an interest in the funding side as well as the acquisition, although nothing specific happened until June 2013. So from September 2012 to June 13, I cannot say exactly what happened in the background and who was approached and why. But what we do know that in June 2013, SA Home Loans was requested by the PIC to enter into several non-disclosure agreements. One was with the PIC, and then for the first time we came across the name Matumi Maponya Investments, MMI. We certainly didn't know who they were or who represented them, but we did an NDA with them, and then there were varying other advisory firms relating to the sharing of confidential information, or the NDA related to the sharing of confidential information concerning the acquisition of a shareholding interest in SA Home Loans.
At this stage, your interaction with Dr. Matjila was when he was in the position of being the CIO?
My recollection, Madam Commissioner, is that when we first spoke to him, he was actually the CIO, and there was no chief executive that we could understand, and that his position changed from CIO to CEO during that time.
Later period, yeah.
Yeah, a later period.
Thank you.
So following the non-disclosure agreements that were signed, we then started to share information and documents as requested, and that was for the purpose of conducting a due diligence inquiry. As part of that process, on the 25th of September, SA Home Loans made a presentation to a group of people at the PIC's offices in Pretoria. It was quite a big group, and present at this meeting was Mr. Kolofelo Maponya, and this was the first time that my colleague, Mr. Kelso, and I met Mr. Maponya.
Do you recall who was there from the PIC?
There were a lot of people there, Madam Commissioner.
At least the main person?
Yes, well, we do know that Mr. Masakesa was there, and my recollection is that Mr. Rogers was there as well.
Just a question here. So from September 2012 to June 2013, did you talk to the PIC? Well, was there some correspondence or some discussions?
Nothing from our side, Mr. Commissioner. So all we knew was the information coming to us from our shareholder and colleagues on the board at JP Morgan that the PIC remained interested in our proposals.
Oh, I see. So there could have been talks with the JP Morgan and the PIC?
Undoubtedly there were.
Yeah, all right. Okay.
So what I do say is this: to the best of my knowledge, at all material times, JP Morgan was the initiator and facilitator of the meetings with the PIC, which subsequently resulted in the GPF and the BHC each acquiring a 25% share in SA Home Loans from JP Morgan. At no point did Mr. Maponya initiate or facilitate a meeting between SA Home Loans and the PIC, nor between SA Home Loans and JP Morgan. During the due diligence, we were informed by the PIC, and here we have some documentation on that. This was when the due diligence started in June. We were informed by the PIC that it could not pursue equity initiatives in unlisted entities such as SA Home Loans unless they brought along a BBBE empowerment partner. And ultimately then it was Mr. Maponya's consortium, the BHC.
Does your documentation, is it in the pack?
Madam Commissioner, it isn't, but I can obviously forward that to the Commission once I'm back in office.
I would appreciate that, and if I could ask our evidence team to obtain the authority, board decision, in terms of a mandate that they can't invest without a BE partner, and so we could get that original documentation and authority to do that from the PIC.
Just another question here. So between September 2012 and June 2013, it could well be that JP Morgan, the PIC, and MMI could have been talking.
Yes, absolutely.
Is that possible?
That is indeed possible.
That we're not sure whether they were talking or not, but the MMI group could have been part of the talks then?
It did so.
All right.
I will just point out that, the final transaction was concluded even well after that, because these things do take a long time. So it was concluded in June 2014. But the final conclusion of that transaction almost replicated what we had proposed in June 2012 in terms of the strategic fit, the intention for the GPF to provide home finance for their members and for the affordable housing market, the equity yield uplift for the PIC, etc., etc. So it mirrored what we had presented back in June 2012, and that was the final transaction 2 years later.
Just one more question. You said SA Home Loans had entered into a non-disclosure agreements with MMI, and then later on we see here BHC being PIC's empowerment partner. Can you just explain what is going on here? Is it BHS or was it MMI?
To the best of my knowledge, we did not know of the BHC. So at the time, and I've looked at the NDAs, at the time we were signing NDAs, the BHC was not part of it, it was MMI. We only became aware of the BHC at a later stage. So we unfortunately don't know at what stage the BHC started to represent the consortium, or was the consortium.
Yeah. Could it be that BHC was going to be the investment vehicle, and the MMI are the advisors to that vehicle?
Indeed, that could have been the case.
It could be. Yeah.
Yes.
Okay. All right.
So I'll move then from the JP Morgan transaction to talking about arranging fees. And the first part of my statement deals with the 45 million arranging fees. So as I mentioned earlier, the business objective, or one of the business objectives of the change in shareholding, was to enable a complementary relationship between SA Home Loans and its other entities to access funds from the second incoming shareholder, in other words the PIC, for the purposes of conducting its business. So upon the conclusion and closing of the equity sale transaction, we moved rapidly into the next part of this, which was for SA Home Loans to seek funding from the PIC stroke the GEPF for such loan facilities. The PIC indeed then indicated that facilities could be made available, which would include a facility for lending to the GPF members and a facility for lending in the affordable housing and traditional home loan segments, and that term sheets would be proposed.
If I understand that correctly, the fact that the PIC then had a 25% equity stake and not a 50% equity stake, or it had split between MMI, did not affect that. The PIC would carry that second shareholder responsibility in full.
Indeed so, Madam
It was not
Commissioner.
expected for the empowerment partner to play any role in that.
And that was explicit.
Yeah.
It was the PIC that stood behind effectively the 50% of the
So the
of the
50%, the PIC stood behind the 50% even though its equity share was 25.
Correct, Madam Commissioner. Before the term sheets were received from the PIC, on 18 December 2014, Mr. Maponya, who had been appointed onto the board of directors after being nominated by the BHC, he called my office to seek an appointment with me on a matter which he said telephonically he could not discuss with me. A brief meeting was held between us on Friday the 19th of December. It was a short meeting and very informal because Mr. Maponya was accompanied by his 2 young daughters. At this meeting, Mr. Maponya told me that he and Dr. Dan had agreed that he was entitled to a raising fee on the GEPF funding lines at a rate of 0.5%. He did not imply at that stage, and nor did I understand, that such a fee would be for the account of SA Home Loans. Instead, of course, I understood that he was coming to tell me because it was a material thing, and if the PIC were to pay such a fee to him, I would get to know about it. So that was my understanding of why he came to tell me.
Did you at any point in time ask or question the relationship of MMI to BHC?
Not at that stage, and I think at that stage it was so blurred for us. The transaction had happened we were unclear of exactly what MMI was, who they were, and what their relationship was with the BHC. These things eventually emerged, but not at that time.
Let's just check something here. So I think it was Mr. Masekeso or Raja saying that the 0.5% was for the advisory part of BHC advising the company to take a stake. So was this different? I mean, the 0.5, was it for the funding or for the advisory of taking the stake?
So that's an interesting question, Mr. Commissioner, which
Yes.
I'm afraid I can't answer because both sides has effectively been presented. Our understanding from the way in which this was motivated and over the period of time was that it was an advisory fee on the basis that MMI had played a role in the disposal of the JP Morgan shareholding to a combination of BHC and the PIC. So I deal later on in my statement because that has always vexed me. I've never understood that an advisory fee should then be converted into a fee on the funding. It didn't make any sense.
Yes, because the first part when I heard this was the advisory fee for the equity
Yes.
stake.
Yes.
But I think from the Standard Bank and the you guys that you are saying is the advisory for the funding, is the underwriting fee, basically.
Yes.
So I'm not sure now which is which.
Well, as I say, both things have unfortunately been interchanged in the way in which it's been presented. Fundamentally, though, our understanding was that the reasoning for any fee being paid to MMI was because they had brought the transaction to the PIC, purportedly so. So we've always had some difficulty that the arranging fees have been based, or underwriting fees claimed by Mr. Maponya has been based on the GPF funding lines. There's no relationship there.
I think continue and then we see how it goes.
Thank you, Mr. Commissioner. So I was taken aback at the suggestion that 0.5% arranging or raising fee should be paid. I couldn't understand the commercial logic or the rationale for such a payment to Mr. Maponya as a third party. After the meeting, I had a discussion with my colleague, Mr. Kelso. He was at that stage the CFO. I indicated to Mr. Kelso that I did not believe that there existed a basis for such payment, neither from the PIC nor from SA Home Loans. The matter was not raised again, neither verbally or in writing with me by Mr. Maponya, until about 14 months later, February 2016. Lots happened in the intervening period. In that intervening period, the term sheets for the GPF funding lines that I've spoken of were provided to us by the PIC. They were tabled to the SA Home Loans Board of Directors on the 22nd of April 2015, a meeting at which Mr. Maponya was present.
Was Mr. Masekesa also present at that meeting?
Indeed he was.
They were both the
They were
non-exec board members?
Yes. They included a requirement, the term sheets did, they included a requirement for an arranging or underwriting fee equal to 0.5% on the funding lines to be paid to the GPF. That was standard practice. I want to stress there was no mention at all of a possible payment to a third party, nor was it suggested at that board meeting by Mr. Maponya that the fee in fact was due to him or MMI.
And typically that fee is for the GPF, isn't it?
The fee should be for the GPF and for its
GPF.
members, that's right.
The advisory fee for the taking of a stake could be a different matter, but the underwriting fee is to the GPF.
That's right.
Isn't it? Yeah.
It is indeed so.
Okay.
An advisory fee could be to any third party that indeed provided advisory services.
Yeah, okay.
So having had the PIC table a requirement for 0.5% funding lines, even though that was standard market practice, I still requested the SA Home Loans Treasury team to appeal against the fee, to have it waived either in full or in part, on the basis that SA Home Loans had to recover this through product pricing, thus financially to a certain extent disadvantaging the GPF members who approached SA Home Loans for home loans. Without such a fee, we could make our home loan pricing keener. So So that was the basis for us appealing to see if we could find a mechanism for it either to be waived in full or in part. Then Mr. Mongala, who I know has been here before the Commission, he responded by indicating in an email that our appeal had been considered by the PIC executives, who concluded that we cannot deviate, and I'm quoting here, we cannot deviate from our normal upfront fee requirement, especially for this quantum of facilities. And so we had to accept that. The final term sheets then embodied the requirement to pay an underwriting fee at the rate of 0.5% to the GPF, and that was approved after a rigorous process by the External Investment Committee of the PIC and by the SA Home Loans Board of Directors, again at which Mr. Maponya was present and Mr. Masakesa was present. Accordingly, the GPF approved facilities to the value of 9 billion rand to SA Home Loans through varying entities that I call SAMF entities, which we set up to manage the financing structures. The transaction documents relating to these entities were approved by the SA Home Loans Board of Directors, again at which Mr. Maponya was present and definitely Mr. Masakesa as well, and they were approved by the board strictly in accordance with the term sheets which the board had also approved. These transaction documents were executed on the 24th of December 2015, and as far as SA Home Loans was concerned, the arranging fee requirements ended there. We clearly were required to pay those arranging fees once we'd accessed the facilities to the GPF. The transaction documents did include varying conditions precedent, which meant that we couldn't immediately access the funding, and those conditions precedent were only eventually resolved once the arranging fee matter had been dealt with, and that was at the end of 2016. I come back to that though, because a lot happened during 2016. None of the parties at the end of 2016 were aware that the matter of arranging fees would resurface at a later time and still indeed be a topic now. On the 2nd of February 2016, Mr. Maponya initiated an urgent meeting with me at which he indicated that MMI would be issuing an invoice of 52.5 million plus VAT to SA Home Loans for a raising fee of 50 basis points or 0.5% of the funding lines provided by the GPF to the SAMF entities, in other words 45 million plus VAT, and then he introduced an additional requirement for 7.5 million to be paid by another entity. It was a housing development fund entity. This was a separate entity owned by the PIC, this is the Housing Development Fund, and that had been established for the purposes of advancing funding to affordable housing developers. That had certainly been conceived from a business case which Mr. Maponya had put forward to the PIC, predating the SA Home Loans equity acquisition by the PIC and BHC. SA Home Loans had been requested to act as the administrator of this development fund. There was merit.
You were asked to be the administrator of the fund, and that had occurred prior to the SA Home Loans in Acton. Did you in any way meet Mr. Maponya at that time, or did you know of MMI?
So no, we were appointed to act as the administrators actually after the equity acquisition. What had happened was Mr. Maponya had taken his ideas for the creation of a development fund to the PIC before their acquisition in SA Home Loans. We were unaware of that. It was only after the PIC's acquisition of their shareholding in SA Home Loans that they approached us on the basis that they wanted an entity that had governance, controls, a service track record, etc., to administer this fund. We thought about it, the board approved it, and we agreed to do that. But that only happened subsequent to the equity transaction.
What's the size of the fund, if you know offhand?
It's $1.5 billion drawdown facility.
This $1.5 billion, was it funded by the PIC? Do you know?
Entirely funded by
Entirely
the PIC.
funded by the PIC.
And not yet fully drawn down.
Yeah,
so it's a facility that is available to be drawn down over a period of, I think it's 12 years.
And it's owned by whom? Who owns
the entity is owned 100% by the PIC.
Oh, I see. Okay, all right. And then that 7.5 million rand fee plus VAT and all that, that is justifiable because there was work being done there, yeah? This isn't an underwriting fee, or there were no funding lines, around that.
It was an advisory fee, Mr. Commissioner, and I was satisfied. I was able to attest to the work done. A lot of work was done. I received an enormous bundle of papers from the PIC, authored by Mr. Maponya and a team of people, research that they'd done, putting forward a strategic business case. So I was happy to attest to the work carried out by Mr. Maponya to the Board of Directors of the Development Fund. And they concluded that the advisory fee in the amount of $7.5 million could in fact be disbursed to MMI based on the evidence of such advisory work.
Just to check another thing, paragraph 30, the fee they've been asked for was for funding line 2, which is the 10 billion rand, is that correct? Or is still for the funding line?
Funding line 1, 9 billion rand.
Yeah, all right.
So our initial funding line from the GPF was 9 billion.
Okay.
And the 50 basis points of 9 billion derived the 45 million fee.
So that fee sort of comes back again?
Time and time again.
Okay, all right, okay.
So having had that urgent meeting with Mr. Maponya on the 2nd of February, he followed it up, and I received an invoice by email from MMI for the full amount of 52.5 million plus VAT. And the invoice recorded it as a transaction origination fee. So, just remember, we now had signed contracts, documentation, term sheets. This was a turn up for the books because we had contracts which required us to pay an arranging fee to the GEPF. So I discussed this invoice with my CFO, Mr. Kelso, who had been aware of the fact that Mr. Maponya and I had met. Our common view was that such a payment to MMI instead of to the PIC would never be sanctioned by the PIC because of these transactions and contracts, transaction documents and contracts. And they themselves, the PIC, would invoice us in accordance with the transaction documents. Nevertheless, I asked Mr. Kelso to inquire from Mr. Mangala at the PIC whether there were any changes to the contractual arrangements that were being contemplated. Mr. Mangala did respond in an email. He confirmed, and I quote, "The PIC on behalf of the GEPF will invoice the borrower," in other words SA Home Loans, "and any arrangement made between the PIC and third parties on the fee sharing arrangements is outside the financing agreements." So he was saying no change to the financing agreements. If there are any arrangements to pay a third party, the PIC would do so. Mr. Kelso and I were not totally comfortable with this response. I indicated to him...
Just for clarity, so if you had agreed to pay the invoice, you would have been paying an equal amount, one for the PIC in terms of its 0.5% that you had agreed to as the fee, and then an additional, so it would have been a 1% payment, not for 50 basis points.
Not at that stage, Madam Commissioner. Eventually, in terms of some amendments to the documentation that they put forward, it could have led to that. But at this stage, we had clear contractual arrangements. It included a payment of only 0.5%, in other words, 0.5%.
Yeah, that I understand. It was a 0.5% to the GPF, but this proposal...
This proposal, we thought, was instead of paying the PIC...
Oh, okay, so you thought it was instead of, not in
of.
addition to,
Correct,
at this stage?
At that stage, yeah. So, we thought we needed to clarify who the third parties were that the PIC contemplated sharing the 45 million with. And that clarity did come later from Mr. Mangalo. I'll deal with that actually in paragraph 39. I corresponded, after receiving the email from Mr. Mangala, I corresponded with Mr. Maponya, indicating that SA Home Loans was going to be billed by the PIC in terms of contract. That's what Mr. Mangala had told us, and hence SA Home Loans would not pay anything to MMI. A few days later, Mr. Maponya contacted me and said that the agreements had a mistake in them because they did not fully capture the actual agreement which he had with the PIC, which was that raising fees of 1% were due and payable, 0.5% to the PIC/GPF, but also 0.5% to MMI. I indicated to Mr. Maponya that I had no knowledge of this, and as far as I was concerned, this was not a mistake, and that SA Home Loans could only adhere to the terms of the agreements that had been signed, and which of course had been tabled and approved by the SA Home Loans Board of Directors.
In which Mr. Maponya and Mr. Masikese were present and approved those documents.
At all of those meetings, Madam Commissioner,
And did
yes.
not raise any issue at that time.
Not once. I was placed under immense pressure by Mr. Maponya. He indicated to me that the mistake was going to be fixed by the PIC and that SA Home Loans would have to honour the invoice. He even asked if SA Home Loans could provide MMI with the SA Home Loans letter confirming that we were processing the invoice, which would be paid in due course.
Sorry to interrupt you. I just want to come back to the board question, because this behavior would have been totally unacceptable for a non-executive director on the SA Home Loans board, given if you're both sides of the equation, and it's the pressure being put on by a non-exec who, at any point in time, did Mr. Maponya disclose to the board this conflict? Was it ever raised in the board of inappropriate behavior by him as a non-exec director in the functioning of SA Home Loans?
So Mr. Maponya didn't raise it with the board, but certainly at a later stage afterwards, I indicated to the board that I'd been placed under intolerable pressure. And I think, the board agreed that this was not suitable behavior. I need to say, though, Madam Commissioner, that hasn't stopped the intolerable pressure, because this issue of the arranging fees has been ongoing and the pressure on it has been ongoing.
Have there been any action by the board to the PIC and in terms of them having brought them on as a BE partner about the behavior on the board and what measures need to be taken, given that from this indication and subsequent that Mr. Masikese, who is there for the PIC as a non-executive director, has also conducted himself in a particular way, as we've heard from other evidence. Was this raised with the PIC as a matter of concern by the board?
It was not raised by the board, Madam Commissioner. I do understand, however, that as a shareholder, that Standard Bank have recently raised such issues with the PIC. I'm not aware that those issues were raised during 2016, the time period that I'm referring to at this stage in my statements. It's a recent thing that I've become aware of. Let me move on then to progress through the year 2016. On the 19th of February 2016, I received a phone call from another non-executive director, Mr. Wellington Masikese, whom we've spoken of. As you know, he's an employee at the PIC. And he informed me that there had, in fact, been, which he called, a loose arrangement of a 1% raising fee, which was to be split between the GEPF and MMI, as suggested by Mr. Maponya. I indicated to Mr. Masikese that SA Home Loans was not a party to such an arrangement and that SA Home Loans could only comply with the contractual arrangements in place. He did agree. He agreed with that, and he said that if anything was to change, the PIC would provide SA Home Loans with what he called a side letter. That's why I've put it in quotations. It did surprise me that there could be any claim that there was such a loose arrangement, as the term sheets had been tabled to the Board of Directors, and this was never raised. The arranging fee in term sheets had always been 0.5% payable to the lender. 1% had never been mentioned to us. The next event relating to the payment of the arranging fees was an email from Mr. Mongalo on the evening of the 4th of March 2016, and I will quote again. We have discussed the mechanics of the arranging fees payment and have decided MMI should invoice SA Home Loans. This would necessitate the amendment in the legal agreement. We would in this regard instruct DM5, those were the attorneys, to prepare an addendum which would allow the arranging fees to be drawn. In this regard, we envisaged introducing the total obligation concept, which would include the principal amount and the arranging fees, which shall be drawn and be repayable as part of the facility. In a nutshell, he was saying we were going to change the already signed contracts to deal with arranging fees that could then become payable instead of to the GPF, to MMI. That's effectively what he was saying. And then proposed addenda to the SAMF. There were two facilities, so we had two addenda presented to us. They were received on the afternoon of the 11th of March 2016. And they did seek to amend the definition of arranging fees which we had in our contractual documents. It was, if I may say, alarmingly vague, with no reference to when the arranging fee was due, to whom the payment would be made, and what the process for payment authorization would be. Also, it wasn't clear that the previously explicit requirement to pay the arranging fees to the GPF had fallen away. And this comes to your point, Madam Commissioner. In fact, legally, with these addenda that had been provided to us, it looked as if SA Home Loans would have been compelled to pay the arranging fees, the full amount of 45 million, twice. Once to the GPF and a second time to MMI. So that was the, if you looked at the proposed wording changes, that was the effect. The addenda had a further element of discomfort for me, in that it could easily be concluded that it was SA Home Loans that had appointed a third party, in other words MMI, as an arranger to the transaction to whom fees could be paid. And that clearly was not in accordance with the facts and the resulting agreements. Furthermore, on the 16th...
Just a question. So, in terms of the fees being asked for, I mean, there was no mandate signed by, parties and all that. Any advisory mandate, origination mandates and all that?
None whatsoever.
Yeah.
As I've indicated, we only met Mr. Maponya late in September 2015. Mm-hmm. So no, we had absolutely no arrangements with him, no contracts, no services were provided, etc. On the 16th of March, Mr. Mangala responded to Mr. Kelso that the original agreement envisaged paying a fee to the GEPF, and the addendum is specifically to amend that, and he also said there is no intention to issue a letter authorizing payment. For every drawdown that SA Home Loan, and I'm quoting SA Home Loan, send to PIC, there is documentary proof required in support of the drawdown. The PIC would need to agree with the invoice amount when presented. The arranging fees invoice was not included as part of the documentary proof in the current draft, but we will now include it as an amendment to paragraph 5.1. So we interpret that as quite a lot of gobbledygook. It didn't make any sense to us. We were told that we could actually draw down inclusive of any arranging fee invoice that had been paid, and that would be approved only afterwards by the PIC. So that is what we were told was the objective of the addenda. And in the weeks that followed, both Mr. Kelso, my CFO, and the company secretary attempted, most unsuccessfully, to ensure that the proposed addenda were clear and unambiguous. Eventually, on the 6th of April, we received from the PIC attorneys a document which they described as an execution version of the addenda to the transaction documents. And they had not addressed the concerns that we had raised. So on my instruction, the company secretary advised the PIC attorneys and the PIC that the addenda did not reflect to whom, when, or at whose instance the arranging fees were payable, and therefore we could not accept the addenda.
At this point in time, other than the PIC legal, you were still dealing with Mr. Mangala?
Yes, we were dealing primarily with Mr. Mangala. In fact, only with him at this stage. I also point out that if an objective third party had to review these addenda, if they'd been executed in that form, the question would naturally arise why SA Home Loans had been so inept and concluded such vague agreements. And therefore the company secretary advised that you could not table the addenda before the SA Home Loans Contracts Committee for consideration. We just weren't prepared to take it further at all. We were told many times that the PIC had in fact had an arrangement with MMI.
By who?
Well, Mr. Mangala was one of those, but certainly Wellington, Masakesa in talking to me, and Roy Rajath in talking to me. So we understood, even at board level, as I will point out, we understood that there was in fact an arrangement between the PIC and MMI. We hadn't seen it, we didn't see documentation, but they certainly indicated that to us. So So on the basis that the PIC had this arrangement and wished for its arranging fee to be paid instead to MMI, and given, of course, that we did not get contractual documents that we were satisfied with, the company secretary suggested to them that they may rather wish to avail themselves of their contractual rights to cede the arranging fees payable to it to MMI. This was communicated to the PIC attorneys, clearly stating that this was on the absolute understanding of a valid arrangement. And of course, a session would then clearly indicate the parties concerned.
But in relation to the comments about Mr. Raja, Masikeso, and Mongalo, if there had been such a fee other than being a loose arrangement, there would have been a document to that effect, and you never received a document to that effect of such a commitment to MMI?
No, we never received it, Madam Commissioner. I think I can point out that if we were to execute the session, that is exactly what we would have wanted to see. And the board of SA Home Loans specifically said that as well. So whilst the session eventually arrived, we certainly would not simply have executed it without making sure that we had the documentary evidence and proof for the requirement to make such payment.
And such documentation was never produced?
No, it's never been produced. And I say later on, in fact, that Dr. Dan informed me that there was no such documentation, but that was at a meeting I had with him in July 2018. But at that stage, we certainly believed that there was a valid arrangement. SA Home Loans management had already internally concluded that before any payment could be made, as I've indicated, it would require the approval of the board of directors and ratification also by our shareholders, because such a transaction involved related parties. I continue to be pressured to cooperate in giving effect to the changes which the PIC had requested. Eventually, on the 13th of April 2016, it was clear to me that this matter could not be resolved, not between ourselves and the PIC or with the PIC's attorneys. And in accordance with our MOI, I requested the company secretary, in writing, to call a board meeting of the board of directors of SA Home Loans to try and sort this matter out, which he did. We failed to secure consent to hold the board meeting on short notice, so it was eventually scheduled for the 9th of May 2016. Before the board meeting, however, I received a letter dated the 29th of April, signed by Dr. Dan from the PIC, and the reference on that was Mr. Raja, a non-executive director of SA Home Loans, but also an executive head of the PIC. And in terms of that letter, SA Home Loans was notified of a cession of the PIC's rights and obligations under a particular clause of the Master Loan Facility Agreement. So that session, or the requirement for us to execute that session, was received on the 29th of April. And I do understand that that paperwork is before the Commission. It was tabled by Mr. Sinton. The board meeting was then held on the 9th of May 2016. Now, unbeknown to me, and certainly possibly most of the board, until more recently, is that Standard Bank had been to visit Dr. Dan at the PIC, taking the session that had been sent to me on the 29th of April and indicating that they considered to be irregular. And as a direct result of that, Dr. Dan withdrew the session. But at the time of the board meeting on the 9th of May, we did not know of that. So the board deliberated at length on the concerns raised in my report and on the session which had been received, and it was during that meeting that the board was informed by Mr. Raja. Clearly, as a result of that Standard Bank intervention, the board was informed of three things. Firstly, that the cession by the PIC of its rights to receive the arranging fees would be withdrawn, that the invoices rendered by MMI to SA Home Loans should be withdrawn, the funding contracts, as we had them, would continue without any amendment. In other words, all those suggestions of addenda could be scrapped. And finally, that the matter of MMI fees in respect to the facilities would be resolved between the PIC and MMI. And thereafter, a day later, a letter was sent to me by the PIC, again signed by Dr. Dan, dated the 10th of May, notifying SA Home Loans and others that the session had been withdrawn. But I need to point out, of course, that Mr. Maponya said at a later stage that he did not accept this withdrawal of the session, as legally It couldn't simply be withdrawn, it was required for him to reseed the claim back to the PIC. A series of discussions at SA Home Loans Board happened thereafter during the second half of 2016, several of them, at which the issue of arranging fees were discussed time and again. And the Board of Directors concluded that, and this is very important, if an agreement existed between MMI and the PIC, that is included in the minutes of the discussion of the board. If an agreement existed between MMI and the PIC and the GPF, then, firstly, the PIC should confirm that an agreement had been executed between MMI stroke Mr. Mapanya and the PIC, in terms of which services had been rendered and a fee was due, and specify the amount of the fee which was payable. And secondly, the transactions between, amongst others, the company, GEPF, SA Home Loans be referred to the shareholders for ratification by way of an ordinary resolution of the shareholders following the disclosure by Mr. Mapanya of his personal financial interests in the contracts. And that was required in terms of the Companies Act.
Sorry, I'm not quite sure if I understand that. Does that imply in terms of B that Mr. Mapanya had then declared his interests?
Yes, he only declared his interests way after these events. So he submitted his invoices to me, he required payment to be made to MMI, and it was only at a later stage. I think it was probably at that first board meeting that I called in April. In fact, I'm clear. It was at that board meeting in April, that was held on the 9th of May, I should say, that he for the first time declared his interests in contracts.
Is that in itself, given that it is late, a violation of the Companies Act, or is it condoned by the board that there was a late disclosure?
It could be condoned. However, what it did require then was for the shareholders to approve such transactions, because the board had approved those transactions at a stage when they were unaware of such a conflict.
So in essence, the shareholders would ratify that there was a subsequent disclosure and it was still okay, even though it had not been disclosed at the time?
Indeed so, Madam Commissioner.
And at this point in time, what was the role between MMI or BHC, or had BHC disappeared altogether at this point?
So BHC was the 25% shareholder, but Mr. Mapanya represented on these instances MMI and himself.
But how does he do that if he's representing BHC on the board?
Well, there was a clear conflict.
Yeah.
So he was doing both. He certainly was on the board at the instance of the BHC. Our MOI basically says that for every 12.5% shareholding, that shareholder is able to elect or nominate a director to the board.
Anyone else that in these interactions, was there anyone else from either BHC or MMI that SA Home Loans interacted with or was aware of?
No, it was Mr. Mapanya.
Yeah.
So, to draw an end to the saga, not quite an end certain to the saga in 2016. Eventually, a letter was received on the 4th of November 2016. We received the letter from MMI, which advised that the session, this is a quote, the session for the payment of arranging fees to MMI has been returned to the PIC with a request that payment should no longer be effected, and confirming, a further quote, that the intended litigation regarding the said payment had been withdrawn, and as such the facilities were beyond reproach and could be continued with. So that seemed, from my perspective, to draw a line under the matter. The Board of Directors was notified of the letter, and it was really recorded by all that personal interests had all fallen away. So I may come back then to a point, Mr. Deputy Commissioner, that you raised about how the fee, this advisory fee, was computed. So I've been struck, as I said earlier, by the lack of commercial reasoning associated with the payment based on the quantum of the GEPF funding lines. Those funding lines could have been from 1 billion to 20 billion, so it could have been any number. We had learned from Mr. Mapanya and others at the PIC that a payment was due to MMI on the basis of its purported involvement as an advisor in the JP Morgan equity transaction. There's thus an absence of logic in applying a formula to the GEPF funding lines. If MMI was involved, as purported, the commercial nexus would be to the purchase price for the JP Morgan shares, which our numbers reflect as 854.4 million, made up of 419.7 billion on behalf of the BHC after their BBBE price reduction, and 434.7 million from the PIC, thus 854 million. A fee then could be computed at 0.5% of 854 million as 4.27 million, a far cry from 45 million. So that was something which we always grappled with, this lack of logic in applying for advisory services a fee to funding facilities.
Yes, which is why I asked the question that actually what is the fee for? Is that for the advisory or for the, to originate the funding lines, And now you can see that there's so much cluttering.
Correct.
Mm-hmm.
Yes.
Mm-hmm.
Correct.
Yeah. Okay.
So we get back, however, because the
Sorry, just on that though, you're still, whatever the amount is, it's still clear that that was not due.
correct, not us, no, could not be paid by any stretch of the imagination by SA Home Loans. In March 2017, Mr. Matjila verbally mentioned to the company secretary that the matter of arranging fees was in fact not concluded and that he would raise it again. Later in 2017, SA Home Loans approached the PIC for a further 10 billion in funding to the relevant entities, and for the better part of the 2018 year, we were in regular contact with the PIC in this regard, on the understanding that some internal approvals were required. The reason why we applied for a renewal was because the 9 billion was almost exhausted.
Can I ask you, just in relation to the internal approvals that are required, because obviously that is required, was this stretching of the time very different from when you applied for the 9 billion?
As it's turned out, yes, Madam Commissioner, but no, not initially, because we started to work on the 9 billion immediately after the equity transaction, which was, we started working on it in July 2015. They then concluded a due diligence, etc. Mind you, sorry, I need to just probably add this. It took about 6 months. This was certainly taking a lot longer. We applied in 2017, and we expected by mid-2018 that we would in fact receive some approval.
And to date, you still have not received approval?
No, we haven't.
So from what date in 2017?
In December 2017.
December 2017 to mid-2019,
yes.
Internal processes?
Internal processes, yeah. So it's been through lots of ups and downs. There are many stakeholders. We have been receiving lots of encouraging noises. Lots of positive information has been fed back to us, including fairly recently, but nothing has yet been concluded on the 10 billion renewal. So we got ourselves into a position in mid-2017 that we may in fact not get renewal. We spoke directly, that is a colleague of mine, Mr. Zakeni Dlamini, and I visited the GEPF and spoke to a couple of their trustees. And they indicated to us that in fact the GEPF might be coming from a position of saying that the 9 billion was a one-off facility. And it was news to us, but they did put it across to us. They didn't say that was absolutely the case. They said that was something which they were considering. And a renewal would be something different altogether. On the 26th of July 2018, Mr. Matjila informed the Board of Directors of SA Home Loans that the issue of arranging fees on the initial facilities back to the 45 million was not yet resolved with the PIC, and therefore it was in his intention to institute legal proceedings against the PIC in respect of the balance of the fees, and that SA Home Loans and myself would be cited in such litigation. Which is now made good on.
Just an issue here. This thing, it's going on and on. Didn't this affect the functioning of the board and the company, the relationships and all that?
Certainly it was a focus, an internal focus that we didn't need. I was the point man on this, so I allowed my team to continue focusing on the operational functions. I did utilize the CFO quite extensively to assist me, but I was the individual that dealt with all of this rather than try to defocus the SA Home Loans team. From a board perspective, our board meets 5 times a year, and I was keeping the board up to speed, as was Mr. Maponya, as I've mentioned, that the issue was not in fact dead, as we had thought at the end of 2016. It didn't affect the functioning of the board, though. I now want to move to a different section, which is to, in fact, add to the 45. So 45 million never disappeared. It was a continuum. It still hasn't gone away, but an additional element was added to it in September 2018. So that was an incident that occurred in the late afternoon. Following an SA Home Loans board meeting, I received a WhatsApp text from Mr. Maponya requesting that I call him ASAP, his words. I'd been away from my phone for some time when I first read the text, but before I could contact Mr. Maponya, I received a call from my colleague, Mr. Zakeni Dlamini. Mr. Dlamini advised me that he needed urgently to talk to me and requested that we meet up soonest. I obviously agreed, and he joined myself and Mr. Kelser, and we went out to dinner. Mr. Dlamini informed me that he had been contacted by Mr. Maponya requesting a meeting, and that he had met up with Mr. Maponya and Mr. Masakesa at a restaurant in Nelson Mandela Square in Sandton. The purpose of the meeting was to put forward a proposal to release this further funding line of 10 billion that we had applied for, which SA Home Loans had requested, as I say, in December 2017, but we'd failed to secure it at that stage. Mr. Dlamini provided an account of his discussions with Mr. Maponya and Mr. Masakesa at great length. On the specifics of what was said and what was proposed, he was clear, he was categorical, and he was unequivocal, reasserting what was said at that meeting many times over throughout the evening. Mr. Dlamini reported to me that Mr. Maponya and Mr. Masakesa had informed him, and this comes in the form of a statement which I have from Mr. Dlamini.
Sorry, is your statement under with a commission of oaths or an affidavit?
No, it was just a statement that he had put forward at my request at the time, which he signed, not in front of a commission of oaths, and not an affidavit.
Sorry,
can we suggest that be done as an affidavit?
Indeed.
Mr. Dlamini's statement be submitted as an affidavit?
Yes, so Mr. Dlamini was certainly prepared to put it in the form of an affidavit. We did take some legal advice, whose suggestion was that wasn't necessary, unless it was required, it shouldn't be done. But Madam Commissioner, you are mentioning that you'd like to see it in the form of an affidavit, and I've no doubt that can happen.
Well, if he himself is not going to come and testify, then we will require an affidavit.
Just to let you know, Commissioner, that Mr. Dlamini was preparing a statement to come and testify as well. It's just that it came in at the timelines that we were given to bring the witness. We couldn't bring them both at the same time.
So, Madam Commissioner, maybe that changes your suggestion of an affidavit, because I do understand from the evidence leaders, they've been in contact with Mr. Dlamini, and I understand he's going to be appearing before the Commission shortly.
Yes, then it won't be necessary to hand up a statement at this stage.
Thank you, Mr. Commissioner. So these are the things which Mr. Dlamini put forward to me that had a discussion. This is Mr. Maponya and Mr. Masakesa had said they had a discussion with Dr. Dan regarding the payment of an arranging fee amounting to 0.5% on the PIC funding lines to SA Home Loans. That the issue of the absence of arranging fees was the main reason SA Home Loans had been unable to secure such funding lines. That Dr. Dan was open to supporting the payment of the arranging fees if a way could be found to regularize, and I've put regularize in inverted commas because it was a word that Mr. Maponya used, to regularize such fees. That is despite Dr. Dan's comments to me during a meeting that I'd had with him in July 2018, in which Dr. Dan had expressly rejected the payment of arranging fees to any third party, either on past funding or any future funding. I'll come back to that point a little later on, Mr. Commissioner. The fourth point, that the ESSA Home Loans management team had to apply their minds on how to regularize two things. Firstly, the arranging fees for the new funding lines being 0.5% of the 10 billion, in other words, 50 million rand in arranging fees. And secondly, to enable the arranging fees that had been rejected on the previous 2016 funding lines, the 45, to also be incorporated into the arranging fee on the new funding line by adjusting the basis points percentage to 0.95%. 0.95% of 10 billion would give 95 million, in other words 50 plus the 45. All such arranging fees were to be paid to MMI. That funding line renewals, which were critical for ESSA Home Loans, would not be successful if the matter of arranging fees is not resolved.
Just another question here. If say MMI said that they arranged the 10 billion rand funding facility and they want a fee, would that be proper, or that fee would still go to the GEPF?
I think that would be very improper, Mr. Commissioner. It would be improper because no work was done. There was no contract. There were no services. The initiator for the 10 billion funding line renewal was ESSA Home Loan. It was a detailed document which we presented. We had presentations, we had workshops, etc.
Oh yes, because you were there before.
Yes,
and
yes.
you sort of presented everything there.
Yes.
Yeah.
So the only possibility of a fee would again be to the GPF in terms of the sort of standard market practice, not to any third party.
You didn't need any third party to
Absolutely.
finalize this section.
We needed no advisory services.
Yeah, okay.
And I might also point out, that if any of our directors, whether they would be Mr. Maponyo or anybody else, had connections and could help us and assist us, well, I would expect that that is part of the duties of a non-executive director, to help the company that they are representing. And I don't know whether he did or he didn't, but I'm just saying if he did, that would certainly be something that I would call absolutely normal.
I would agree that that is the responsibility. You're there to play a role, but is there not a different question in relation, and I'm coming back to the continued presence on the board of two non-execs acting in this manner, is there not a question of fiduciary duties and inside information? As board members, they would have known that you were planning as home loans, they are board members, to get the additional 10 billion rand funding. And therefore, that is information privileged to them as board members as part of their duties there, and to utilize that information to, in essence, extort, because that's what it would look like to me. If you don't pay this, you are not going to get the 10 billion. The duty of a board member is to advance the interest of the company that you are there representing, and therefore to put it as an obstacle unless there are fees. How was that interpreted by the board, and were any steps taken in relation to their fiduciary duties, the ethics and values of a board member in relation to this behavior, and again taking it back to the PIC as the sponsor of the BEE transaction and bringing them on board, and Mr. Masikesa representing the PIC? If, because that is a person, if one has to look at this, Mr. Masikesa's behavior is on behalf of the PIC. So what was the board's response to that?
Madam Commissioner, so the first part of your question, it certainly is a breach of the Companies Act, a clear-cut breach, utilizing insider information that they had to benefit themselves. Clearly also a breach of fiduciary duties and many other things. So the board is deliberating on this even as we speak. So this is a more recent event. There were a series of things which led up to my reporting this to the board first, which I'll deal with in a moment, and we now have had an emergency board meeting with more to follow, and these are specific things that will be and are being addressed, with conclusions which at this stage are obviously unable to put forward because we haven't got there. And the shareholders as well, because this was a matter I first reported to the shareholders for reasons I'll explain in a few moments. The final point, and I'm quoting all of this from Mr. Zakeni's statement, so none of this, these are not my words, these are his words. And the final point that he made was that Standard Bank would support the payment of arranging fees on the funding lines if their payment has been regularized. So just to be clear, my understanding of this comment, which came from Mr. Maponya and Mr. Masakesa, is not that they'd obtained confirmation of support from Standard Bank, but rather that they thought that Standard Bank would support such a payment if the SA Home Loans management team motivated to regularize it in some form. Mr. Dlamini continued to inform me that they had required certain action items, and these action items were first, that he, Mr. Dlamini, inform me of the discussion, and that the two of us together explore solutions for regularizing the arranging fees, that if necessary, that he and I meet with Mr. Maponya and Mr. Masakesa to discuss the matter further on Thursday, the 6th of September, that we develop a proposal, but only share it with Mr. Maponya and Mr. Masakesa, and I don't like secretive things, so that really would always have worried me, aside from everything else in any event. And if all was in order, the proposal would be presented to Dr. Dan by Mr. Masakesa. The following day, on the 6th of September, I spoke briefly with Mr. Masakesa. We were both present at a Housing Development Fund strategy workshop. Mr. Masakesa confirmed the substance of the meeting as outlined above, and in response to a question from me, he directed that SA Home Loans should not approach Dr. Dan on the matter, as he would personally do so once, or I should rather say, if a proposal to regularize the fees was received. I want to be clear. SA Home Loans would never accede to such a request. A matter of concern for me, however, was how to respond in a way that would minimize the negative reaction from Mr. Maponya, given my past experience on such matters and the pressure brought to bear during 2016. I reported the incident as soon as I could to the company secretary, which was on Monday the 10th of September. It would certainly have been earlier, but she was on annual leave. The company secretary's advice was, and I knew it of course, this was a serious incident and required reporting, that the board of directors should be informed and that legal advice should be sought on the reporting obligations which she believed had arisen. I of course agreed with all of that. On the 20th of September, so just taking the matter a little bit forward on how we could respond to Mr. Maponya, at my request, following varying discussions between myself, Mr. Kelso, whom I brought in on this, and Mr. Dlamini on how best to answer, Mr. Dlamini informed Mr. Maponya telephonically that we had given the matter due consideration, but that we could not implement his proposal as we were unable to identify a commercially justifiable reason for the payment of arranging fees that would pass the scrutiny of our board, our shareholders, the auditors, and any other stakeholders. That was our delicate way of saying no. Having discussed with the company secretary the reporting obligations, which included reporting the matter to the board, it was my determination that the better immediate channel of reporting was to the shareholders. This is not a reflection on the board, but it is a direct consequence of our memorandum of incorporation, which requires total unanimity amongst the shareholder-appointed non-executive directors on any material decisions or resolutions. That is what is required. There was also...
Was a question there, well actually you did.
Yeah. There's also clear conflict given the involvement of the two non-executive directors. So, in my view, these two individuals could not act as their own prosecutor, defense, judge, and jury. I believe that only the shareholders can convene, I believe that still, can convene the appropriate forum to discuss the incident, provide the non-executive directors with the right to respond, and take the appropriate action. So, the following steps were taken. Firstly, Mr. Dlamini was requested to document the discussions of the meeting, and he did so. I briefed the chairman of our Audit, Risk and Compliance Committee. I sought a meeting with the Standard Bank Group shareholder representative. Standard Bank at this stage were the only shareholder that had not had a related party at the discussions. That meeting was subsequently held on the 12th of November, and present at that meeting were Ian Sinton, the chairman of our Audit, Risk and Compliance Committee, the company secretary, and myself, we briefed a senior counsel requesting legal advice on varying pieces of legislation and obligations, and I, of course, requested Mr. Dlamini to put this into a statement, which he did. At that meeting with the chairman of ARC, which I was able to have with him on the 29th of October, I briefed him in full, and I explained why I believed that this was not a matter which could be resolved by the SA Home Loans Board, given the construct of our MOI, which required board resolution to be supported by all of them, and that it should therefore be reported to the shareholders as contemplated in our MOI. And as I say, I did that with Mr. Sinton and others on the 12th of November. So just to complicate matters even further, towards the end of October 2018, the new CFO, Mr. Matthew Much, and I were asked by our external auditors, Deloitte, to answer a question on whether any event of any nature had occurred in the business which caused us to be uncomfortable. And clearly, I was uncomfortable. I gave a brief verbal synopsis of the incident to Deloitte, and the next day they informed me and the CFO that they may need to abandon the audit unless appropriate action could be demonstrated. They didn't simply say that, they obviously put reasoning behind it. They were uncomfortable, not necessarily with this as a specific incident, but compounded by what had happened in 2016, where an environment where non-executive directors were placing such pressure on management. And that was what they were concerned about, and were concerned about continuing with an audit under those sorts of circumstances. I'd informed them that I was to report this to the shareholders and obtain legal advice, and they remained on the audit at this stage. While these talks were happening, so another intervention, in October 2018, SA Home Loans was requested by Mr. Maponya to assist in supporting and motivating payment of the 45 million arranging fees by the PIC to him in respect of the original master facility agreement. So this 45 came back. On the 7th of November 2018, just a few minutes before SA Home Loans board meeting, Mr. Maponya requested of the company secretary that his request be placed on the agenda for discussion by the board. The matter was raised for discussion as follows. This is a quote from our minutes. Management has received a request from Director Mr. Maponya in respect of the GEPF facilities which were granted in 2016 to reopen the issue of raising fees on these transactions and for management to assist him to the extent permissible and possible with his motivation to the PIC in this regard. The outcome of the discussion at the board meeting was that the matter had been considered in detail previously, that there was no new information which needed to be considered, and therefore there was no reason for the matter to be reopened. Management was mandated to respond to the letter we'd received from MMI, which of course we did. So getting back now, after those interludes, to the 5th of September incident. After meeting with Standard Bank as shareholder representative, I planned also to meet with Dr. Dan in his capacity as the PIC shareholder now, or as a shareholder representative, and to inform him of the incident in exactly the same way I'd taken it to Standard Bank. However, he left the employ of the PIC on 23 November before I could do so. I did not intend to check with Dr. Dan on whether he had authored or was behind the request for the payment of arranging fees on the new facilities, and for two reasons. The first reason is that I had met with Dr. Dan as recently as July 2018, shortly before the incident in question, where Mr. Masakesa was also present, where Dr. Dan had roundly rejected the payment of fees on GEPF facilities to any third parties, not for the past nor the future. He was abundantly clear on this point, which led me to believe that his name had likely been brought in as part of this concocted proposal. I had raised the issue of fees with Dr. Dan in July to let him know that Mr. Maponya was threatening legal action on the 45 million arranging fees. Dr. Dan was vigorous in his response, and at that stage he told me that Mr. Maponya / MMI had not delivered any services, and that there was no contract, and that I should go back to Mr. Maponya and tell him to bring it on. Those were Dr. Dan's words. So I had no reason to ask Dr. Dan whether or not he'd authored this. He'd already clearly told me he wasn't going to be party to those sorts of things.
Can I ask whether Mr. Masikesa was present during that discussion?
He was present during that discussion, Madam Commissioner.
And did you ever question him as a non-executive director, being the chief of staff in Dr. Matjila's office, how he could have a view so different from what his CEO was saying?
Well, I didn't discuss this particular incident with him because he was involved, Madam Commissioner. So no, I haven't addressed that with Mr. Masikesa. The second reason why I wasn't going to talk to Dr. Dan about the proposal was that I had rejected the proposal out of hand, no matter who may have been involved, and I didn't need confirmation or denial from any parties of their involvement. It was never going to happen. My desire to speak to Dr. Dan was only in his capacity as a shareholder representative. Following the meeting with the representative shareholder Standard Bank and my feedback to them that I had been unable to contact Dr. Dan, and furthermore that I was unclear to whom I could report the matter at the PIC. They were in some disarray at that stage, boards all resigning, etc., etc. And that Standard Bank would likely have contacts at PIC board level, which I did not have. I believed that the matter would in short time be resolved at shareholder level, which was, as I've indicated earlier, the only possible forum to reach resolution. We eventually received the necessary legal opinions from a senior counsel, which advised on our required courses of action, and following this, I prepared fully to report the matter to the auditors, our Audit, Risk and Compliance Committee, and the Board of SA Home Loans, all of which I've done. I can add, Mr. Commissioner, that I have supplied all of those legal opinions to the Commission. We received 5 of them because we've got discrete opinions on every bit of legislation. The Board of SA Home Loans met...
Sorry, just in relation to tabling at the board, I'm assuming that both non-exec directors in this matter were present at those board meetings?
They indeed were.
And I'm assuming that you may or may not be able to tell us what their reaction was to all of this?
I think I'm able to tell, Madam Commissioner. So, vigorous, I guess, rebuttal and denial. One of the directors concerned accused me of lying, accused me of making up the entire event and authoring it, of putting pressure on Mr. Zakeni Dlamini to sign this document which I had authored and putting his name behind it, and other things like that. The second director was not quite as vigorous in that sort of rebuttal, indicated that the meeting did happen, but he was entitled to the fees. That's effectively, it was a long board meeting, and I deal with that in my next point. The directors concerned were to present their statements of response. The incident and any actions flowing therefrom were not resolved. Instead, the board agreed to deliberate on them again shortly after the conclusion of certain regulatory aspects, primarily relating to the auditors and the approval of the annual financial statements. So further board meetings, or at least one further board meeting, needs to be held. So that is the feedback that I can give. My final point is that this incident in September triggered my corporate governance, fiduciary duties, and reporting obligations. It wasn't a personal choice. These are obligations in law by which I have abided. That and only that has been the substance of my reporting to all the parties concerned.
Last week, Mr. Ian Sinton had testified that this matter was reported to the Hawks. Do you have a case number, and on which date you reported it, and who did you report?
Yes, I reported the matter to the Hawks, the Directorate for Priority Crime Investigation. I reported the matter on the 2nd of April. I sent a detailed report to them in terms of the corruption watch line, or the actual formal site. So that was sent on the 2nd of April, and I do now have a response from the DPCI and a case number.
What was the response?
So, the response was acknowledging that I have reported this in terms of Section 34 of PRECA and advising me of a specific unique case number.
Sorry, section 44?
Section 34. 34 of PRECA. The Prevention and Combating of Corrupt Activities Act.
PCCA, because Mr. Sinton said the breaking of the law or the purported breaking of the law was the PCCA, not the PRECA.
I'm not sure that I understand the PCCA.
The prevention PCCA.
Yes, no, that is
the
we're talking about the same thing. I call it PRECA. That's the Prevention of and Combating of Corrupt Activities Act. Yeah, PCCA is one way of calling it. I call it PRECCA, PRECA.
Okay, because Judge, I think there were two laws. There's a PREC and the PCCA, or is the same thing? Is it the same thing?
I believe it's the same thing,
It's the same
Mr.
thing.
Commissioner.
Okay.
Section 34 of the Corruption Act.
Okay.
One last question. There's an internal document from the PIC which was added as an additional annexure to Mr. Sinton's statement last week, which I'd asked him to read, and I'm going to read it to you. And it's called the appraisal report from the PIC. And according to the project description, Namasec Pty BH Consortium approached PIC to jointly acquire JP Morgan's 50% shareholding in SA Home Loan Investment Holdings. PIC will acquire direct 25% equity stake in SA Home Loans for 469 million and finance the BH Consortium to acquire 25% shareholding for 469 million. This document was signed by Dr. Matjila and Roy Raja on the 1st of November 2013. What is your comment after all you've shared? This is the document that was tabled in the PIC, and by the looks of things, BHS was the originator of the transaction.
So my statement as shown is that I do not agree that that is factually correct. I can go back to 2012 and the presentations where ourselves in consult with JP Morgan made the first overtures to Dr. Dan and the PIC. I have tabled the actual presentations, the rationale, the further documents that we actually developed at the request of Dr. Dan, which demonstrates that we were the originators of this transaction. So I cannot agree that that is correct. What I have said earlier on is that we put our documents together and had our discussions from June 2012 to September 2012, and the next time we got involved, aside from hearing from JP Morgan that the PIC remained interested, was in June 2013 when NDAs were signed. So we don't know what happened, as I've said earlier, in that intervening time, and it's quite possible that MMI stroke the BHC, it's Mr. Mapanya were involved. But I am clear that from the first approach to Dr. Dan, and in terms of the presentations that we put forward, it was SA Home Loans, our ideas, pitched also by JP Morgan. And I can also point out, as I said earlier, that the final deal resembled exactly what we had presented in 2012.
I don't have any other questions, Commissioner.
Just two questions to follow up. Where were you reading from? I mean, you know what you've just read?
It's the appraisal report that was submitted as an additional annexure to Mr. Sinton's statement last week.
Yes, okay. Yeah, we did get it, eh? Yeah, we did. Yeah. The question here is this, is that if the PIC had an arrangement with the other group, I think it's BCH or the MMI group, wouldn't that be a payment separate from the fee to raise the funding lines which goes to the GEPF? Wouldn't this be two separate payments, two separate issues?
Yes, totally so. That would certainly be our view. That, as we discussed earlier, would be around advisory type fees. Advisory fees are determined in a different way, but totally separate from the funding arrangements.
Yes, and the question is that if there are such fees, who advised who? Sort of who advised which company, and was there a mandate, and what charges were they? And because you mentioned that even if you calculate the fee, it's about 4.2 million if there was advisory fee for the transaction itself, isn't it?
Yes.
Like,
Well,
am I correct?
yeah.
Am I correct?
Yes. I'm suggesting that that could be another mechanism for determining it, 50 basis points on the value of the share transaction. Yeah.
Yes, yes. You know, Advocate Ko, was there a basis point fee on that particular report? Was there some pricing for that transaction? Or it was just say they will pay a fee? Surely there must be some kind of basis points,
Can
will
you
pay
just-
1%.
We'll get back to you just now.
Yeah, okay, all right.
I do make the point, if I may, Mr. Commissioner, that what has just been read out is very much at odds with what Dr. Dan told me when I met up with him in July 2018, and he was clear and unambiguous. He said there was no contract between the PIC and Mr. Maponya stroke MMI, and that no services had been rendered. So I'm interested to hear that, because he signed that document as well. And that is very much 180-degree opposite what he told me, which was there were no such things, no contracts, no services, no fees due.
Commissioner, can we provide the commission with the information later on when we go through the legal documents and all that was signed? Thank you.
Sure, no, it's fine. And then the final question from me is on the 10 billion rand funding lines. You said that the PIC said the GEPF is no longer, it doesn't want to participate in the second line, or you said that the trustees said that, I just because we need to check this with the GEPF. Yeah. What is your point on that issue,
So,
on the 10 billion?
We've been through different stages on this one. So at one stage, deep into 2018, once our funding renewals hadn't happened, Mr. Dlamini and I met up with the GPF at their offices with two of their trustees, where we did our own pitch, trying to establish if there were any concerns that they had in terms of the renewal of the funding lines. It was at that meeting that it was suggested to us by the two trustees concerned that there had been this thought that the 9 billion given to us in 2016 was in fact a once-off. Now that has been revised since then. Whilst we haven't met up directly with the GPF trustees, we have information coming to us from all the varying stakeholders from the DPSA, the Government Employee Housing Scheme, within the PIC, etc. itself, that they have revised that view and are very much keen for the renewal, the 10 billion renewal. So we've been fed a lot of positive information subsequent to that original meeting with the GPF.
Yes, because we do have the concern is that people need houses, and if they can be funded, then it needs to move on.
Yes, we are using alternative funding lines. We're very diversified in terms of our funding. It's not an absolute need for us. We are still granting home loans to government employee pension fund members, but utilizing other facilities. It's altogether easier for the funding line to come from the GPF, where we can have a bespoke product determined by ourselves in conjunction with them, not necessarily something which fits into the sort of funding support that we get from our other investors, a different type of product. But we are still servicing them, Mr. Commissioner.
One would assume that it would have a pricing difference if you got it directly from the GPF?
The answer to that is we hope so.
It would be. And secondly, when did this meeting take place with the two trustees?
I need to get back to you, Madam Commissioner. I think it was probably around August, but I will get back to you on that.
Last year?
Yes, last year.
So that's nearly a year ago.
Yes. I will get back to you on that.
Is that the evidence for the day?
Sorry, that is the evidence for the day, Mr. Commissioner.
Mr. Penwardine, it's left for us to say to you thank you so much for your time. Thank you for being prepared to come and testify before us. Certainly you've given us quite a bit of information, and we're grateful for that.
Thank you, Mr. Commissioner.
since there is further information that is required, it may well be that you would be required to come again, and I hope you'll avail yourself again, if that happens.
I will indeed do so, Mr. Commissioner.
Thank you very much. You're excused.
Thank you, Mr. Commissioner.
What's the position?
Mr. Commissioner, that is the business for the day. As explained to the Commission earlier this morning at a meeting with the Commission, the investigating teams are in need of a break because of the volume of work and other reasons that I don't have to go into detail at this moment. And we request an adjournment of the Commission till the 18th of June, when hopefully we'll be ready then to proceed presenting evidence at the Commission. But for now, we need time.
I did that on purpose to get you on your feet so that the public may hear it directly from you. We accede to the request, and we shall then adjourn until Tuesday, the 18th of June.
It is greatly appreciated. Thank you, Mr. Commissioner.
Yes.
I just, for the sake of clarity, Advocate Libber, it's a question that we're having no hearings during that period. They are not on break. They are doing work, preparing the documentation and doing their investigations. A break could be misinterpreted.
Thank you very much for that, through you, Mr. Commissioner. The legal and forensic teams will be going at 150% to be ready on the 18th of June. There's no break for us. Thank you very much.
On that note, we shall then adjourn.
Só deixa essa coisa.